All right, good morning, everybody. My name is Sonny Barkats. Many of you know me. I'm the founding partner of J.S. Barkats, a boutique law firm, Midtown. The accent is French, and I do shower, for those who wondered. I'm going to talk to you about something very dear to my heart. I think the economical climate has changed drastically in the past few years, and we all are in front of an opportunity to make a difference. The Jobs Act is an amazing piece of legislation, a bipartisan piece of legislation, but it has a lot of gaps and a lot of issues that are unsolved, probably due to different lobbying groups or interest groups, and it may make it irrelevant really for the long term. I recall, Ecclesiastes 1:9. I'm not a preacher, but I remember King Solomon's writing about nothing is new under the sun. And at the setback, we created a task force, 5 attorneys, 1 accountant, and we decided to look in all the options out there that make more sense for entrepreneurs, bankers, and the future of capital formation. And we went back into the 33 Act and looked at Regulation A. So if I told most of the entrepreneurs that I'm talking to that you can solicit accredited and non-accredited investors, raise $5 million, and you didn't need an audited financial statement for that. Most of them look at me and they were, oh, I can't believe it's legal. Yet it is. And sadly enough, that exemption under the 33 Act, Section 3B, is not used enough. So in the past, I would say from 2009, March 2009 till March 2011, there were about 40,000 Reg D offerings. Out of those 40,000 Reg D offerings, oh, I forgot about pressing the, I have to wait a second on the one before. Sorry about that. Here we are. Out of the 40,000 Reg D offering, the median offering was, for 2/3 of those, of about $1 million. Now, Reg D doesn't allow you to solicit. Reg D prohibits non-accredited investors from participating in the offering. Only accredited investors can be involved, aside from the 35 non-accredited provision. And if people are considering fraud as a big issue, Reg D is not overseen by any regulatory body. Now, I personally believe that it is the job of the investment banking community to quarterback Regulation A. Regulation A today, as it is, allows you to raise up to $5 million from non-accredited investors. You do not need audited financials, but a mere review. And indeed, you need to file a offering circular with the SEC. The biggest impediment today with Reg A, as it is, and not the potentially amended Reg A, which everybody calls Reg A Plus, is that it doesn't preempt blue sky laws. Now, blue sky laws in some state may be a big impediment, but in most states, it's a mere review, aside from 17 states where we have a merit review. But I would say it can be also advantageous because it's an additional layer of scrutiny. In the same period of time, there were only 19 Reg A offerings in the US. I think last year we had, in 2011, we had $905 billion raised under Reg D. And we had only about $100 million raised over under Reg A. So I'm here to educate a little bit and open a debate. But the reality is I'm pretty passionate about the fact that I think that Reg A has the potential of changing capital formation as we know it here. Title 4 discussed the potentiality of amending Reg A, we'll call it for purposes of this discussion Reg A plus, and increase the threshold to 50 million. It does require this time audited financial. The consensus in the legal community and the financial community is really that Reg A plus is going to amend the existing provisions today of Reg A. I hope not. Personally, I think we should have two separated offerings. A 5 million cap with no audited financials, with a filing with the SEC, accredited as well as non-accredited investor being allowed to participate. So I came from France and I thought I'm coming to the country of capitalism and I love this country. Then I realized that non-accredited investors, people below a certain threshold, were prohibited from participating in growth and capital formation. Basically, most people in this country are not allowed to have the opportunity of investing in speculative investments unless they qualified as an accredited investor. I think I put the definition here somewhere. Now, I believe it's time for the investment community to get involved into the democratization of capitalism. And we are sitting now in a time where we are allowed to give comments to the SEC who's about to implement the Jobs Act. And I think everybody should participate. Everybody should have an opinion. I'm trying to convince my views. But everybody should get involved in whether or not Reg A should stay as it is and lobby for Reg A to preempt blue sky laws, which is the biggest impediment of that exemption under the 33 Act right now. So I'm open to discuss statistics, give some information, and we have created a platform where today, with the internet, access to social media, you can use Regulation A as a crowdfunding-like platform with no audited financial. Ask for any person in your state to participate in your investment in the merit state reviews, blue sky states. You will need to justify the valuation, and I think that's the job of the investment bankers. We are here at NIBA with the biggest specialist in the small cap, micro cap investment community, and I think this is where the future will allow that investment community to lead the way and the path. So I wanted to show you what Reg A has done so far, and it's pretty mediocre because the only explanation we came up with is it's either unutilized because of lack of awareness or because people believe that the cost of the filing with the SEC are much higher than drafting a PPM on the Reg D, and they are not that much higher. You don't need to be, and you cannot be, a reporting company in order to qualify for Reg A. If you are, you're precluded from filing that offering circular. And therefore, Reg A is really not that expensive, especially because you don't need audited financials. The review financials are, even at big firm, we did a little scale of study. They don't go above any $50,000 or more, so everything is below that. So the costs are really not the impediment, and that's why we believe it's time to bring that debate up and have people get involved and see more Reg As. So now I'll take some questions. I think touch everything, please.
I got a question. I mean, if I buy 1 unit of somebody's private placement, I usually spend a day and a half, 2 days just answering their questions about it. I can't imagine if I did a Reg A. I think that's why a lot of us, I don't want to do a Reg A because they're going to ask me 2 months of questions about it. And, you know, it's a business decision. Do I want to spend time with regulators talking about something for 2 months, or do I want to do a small deal? So I'll pass.
Well, the answer is very simple. When you do a Reg D, it's under the radar. The limitation you have is you cannot ask for non-accredited investor to participate. So unless you have a big portfolio of accredited investors participating in your offering, maybe you're right. Maybe you should do a Reg D offering. Nobody will ask you any question. FINRA is not going to review the investment banker as an underwriter on the offering prospectus because you don't need an underwriter. The reasoning behind the prospectus and the circular is just an informative circular. It's not like an S1 or an S3 or a registered offering. The scrutiny, the level of scrutiny is much lower. It's basically an SEC merit review scrutiny, so they don't ask questions. If there is a banker, there is a banker. You don't have to have one. If you have one that wants to act as a placement agent or an underwriter on the book, then you will have to answer those questions.
I'm thinking more after the fact.
After the fact?
You know, after, not being the issuer, but after if I actually participated in any Reg A offering, I would think they would ask me an unduly amount of questions for the next 5 months. That seems to me that's the case. Have you found that to be the case of Reg A's?
No, I'll tell you the truth. The 3 Reg A's we filed, the 2 that were completed, went very smoothly, which is contrary to statistical analysis that we had. The average time frame for a Reg A is about 200 days to get effective, and we got them much faster for some reasons. So my experience is limited to that, and there were not many questions. It looked, I think I don't know how FINRA approached it because we didn't have any investment banker sponsoring the investment. But if you're talking about you representing a pool of investor participating into a Reg A, I don't think you will have any issue with that.
It's not the question. He's an investment banker, so he's worried about the sitting in the office with FINRA explaining why he did a Reg A. You're talking about the SEC.
Correct. I have no idea.
Yeah. I think that's why we stay away from it. It's a business decision.
Okay. Yes.
Would you put the slide back on with the comparison while we're discussing the questions?
Sorry.
It's a great slide.
Did you say this is an unlimited number of investors?
Yes.
Does your system increase the competition between the investor and the investment banker as far as one doing it in favor of the other? Does this enable the accredited, does this enable the issuer to have more ability to compete with either their own investment banker or investment bankers or dealers?
Well, we need to compare Reg A with 3 different types of offerings. The future offerings, crowdfunding, which is, in my opinion, completely useless. It's limited to $1 million, and you need an audited financial after $500,000, and you could do it on your own. The Reg D offering, which you draft a private placement memorandum, some issuers or entrepreneurs will be smart enough to go and engage an investment banker to quarterback their offering. And Reg A offering, which you can also do on your own, but comparatively to Reg D, you would use an investment banker to make sure that everything is done properly. So I don't think it competes between entrepreneurs or issuers with their own investment bankers. I think it's an added value, and I think it makes it much more formal and more expertise is required for a Reg A, and therefore it makes the investment banker much more valuable.
It may be, but like Reg D 506, it enables the issuer to do it directly. That's one.
Pardon me?
It enables the issuer to go directly as an issuer, like as it does 506.
Yeah, but Reg A also allows you to do it directly.
Will you clear SEC comments?
You do clear SEC comments, that's correct. You do have to file an offering circular. The SEC reviews it. They have 30 days, 27 days officially to respond, and therefore you have another layer of scrutiny. It legitimizes your offering if you want to look at it that way. You know, one of the big concerns of the crowdfunding provision were fraud. Here you have an SEC review. All right. Thank you.